Hi everyone, welcome to our second video to introduce legal writing. I have a lot more slides on that PowerPoint presentation, but I was not going to record the entire presentation for you because I want to be able to go over this in class as well. So for understanding what we're going to do with legal writing, I wanted you to listen to that first video to kind of understand where we're going to come at in terms of drafting the legal memorandum. And I left off by specifically talking about the two pieces that we will need to have to bring the memo together. And number one is an understanding of our client's facts. What happened? What was that client's story? And then the second piece related to that is, of course, what is the applicable law? And we will go through our research steps again. We'll talk about jurisdiction and mandatory authority and finding cases and statutes. So we're going to bring together both the facts and the law in order to predict an outcome for our client. And when we do that and we put it all together in a piece of writing, we call it the inter-office memorandum. Now, I scanned this in from your textbook, but in Appendix B is this sample memorandum. There's actually a couple of others in your book too, but this one is my favorite. It's not perfect. It's not, no piece of legal writing is perfect, except maybe some that I've drafted. But in all seriousness, this is a very good sample for understanding how a memo comes together. So what we're going to do over the next few weeks is learn how to take the client's facts, learn how to put all of the research steps together so that we then have collected in front of us some research, and then predict for our client an outcome, and then be able to put it into a piece of writing. But when I left off at the last video, I was mentioning that this is a very structured piece of writing, and there's structure even within the structure. So I promise we're going to walk through this step by step over the next few weeks, but I wanted to jump ahead just to show you what the finished product looks like and how we are going to come to put this together. Remember, this is an objective, neutral piece of writing because we want to be able to tell our client, honestly, do we think they're going to be successful or not? Unfortunately, sometimes we even have to tell our client that the law is not in their favor. That doesn't mean the precedent is not applicable. It just means that sometimes maybe our client doesn't have a strong case, or maybe the outcome looks not so good for our clients. And then from there, the client can decide to bring a case, to settle a case, to have a plea bargain in a criminal matter. All of this is taken into account. So I very briefly just wanted you to take a look at the components of the memo. You can see that it actually looks like a memo. I'll zoom in a little bit. It begins with a to, a from, a date, and a regarding line. I'm going to go over all of this in class in great detail, but I do want you to just have a quick look at it now. Every single inter-office memo contains sections. Some of them are in slightly different order. I will say sometimes the facts section is first, but the sections are pretty much the same. There's a section called Question Presented and a section called Brief Answer. These are very fancy ways of saying the question presented is really what is our legal issue here? What are we being asked to research? That's the question presented. And the brief answer is what do we think the outcome is? Here it involves a negligence case. I'm not going to spend time on the PowerPoint of this video reading this to you, so you can pause it and read it on your own. But you can see from reading the question presented, you can learn what was the legal issue that this attorney or paralegal was being asked to research. And with the brief answer, you can see what was the ultimate conclusion reached by the author of this memorandum. Notice a couple of things. Neither is very long. It's one question and one answer. There's not any case citation or lengthy explanation here. This is an opportunity for you as the reader here, just like anyone else, to say, okay, I see what you were being asked to research, and I see what the outcome is here. We'll talk in class about what it's like to predict for a client whether their case will be successful or not. Some of us are uncomfortable with that, right? Because I'm not the judge, I'm not the jury. I don't have a crystal ball to be able to tell you, yes, 100% your client is going to win, or no, 100% the client is going to lose. We can't possibly know that, but we can make a prediction about the law, can't we? Why can we do that? Because we've studied how precedent works. So we know that precedent is the idea that cases have been decided before us. Cases that have similar sets of facts, right? Not 100% the same, but a similar series of events, and a similar legal issue has been raised in prior cases. And we can read those prior cases, and we would call that the legal research. And we can learn from the outcome of those cases how to predict the outcome here, right? We're going to walk through an example in class, and we'll talk about how. So in the legal memorandum, we introduce the question presented, the legal issue for research. We reach a conclusion. So these are the first two sections. We always have a section called facts, where we repeat the story of our client. And then I'll just scroll down, but I'll pause here because then there's a lot. This goes on for a couple of pages. The discussion section of the memo is where we do the heavy lifting. This is the section where we take the existing law and we apply it specifically to our client's facts to predict the outcome. That's what happens in this section here, the discussion. I'll say it again. We take the existing law, our research, and you can see that there are case citations here. So we take the research and then we apply it specifically to what happened to our client. So then we can say, yes, the case is going to go one way, or no, the case is going to go another way. This skill, this organization here has a name. I'm going to introduce it to you on the PowerPoint here. It is called Issue, Rule, Analysis, Conclusion. It's called IRAC. And I don't mean IRAC the country. That's a different place. This is IRAC. And it is a format, and I even like the word formula better. It's truly a formula for legal writing. So what we are going to do in class starting this week is we're actually going to learn about IRAC so that we have the building blocks to do the legal analysis and writing, and then we're going to put that into the inter-office memo. Let me say it another way. Your discussion section of the memo, which is that section that I had open before where you could see cases cited in there, and that discussion section is where we take existing law and we apply it to the facts of our client's case, and that's where we do that legal analysis. There's a format for how to do it. In other words, there's a formula, and it follows this: issue, rule, analysis, conclusion. Every sentence in your discussion section will have an issue sentence, will either be an issue sentence, a rule sentence, analysis, or conclusion. You can literally organize and label your legal writing like a formula. What this means is it's not stream of consciousness. It's not like read a case, discuss, read a case, discuss, read a case, discuss. That would be all over the place. So what we're going to do with our class time is learn how to build an IRAC. And we have lots of examples in the book. Sack and Shop is a great example. There's another memo right after it called the Macmillan Battery example. Both Sack and Shop and the Battery case show us how to, with our legal writing, do issue, rule, analysis, conclusion. But in class, we're actually going to do another one involving burglary, and we're going to build it together in class. I promise we can do it. So take a look at chapters 19, and then take a look at 20, 21, and ultimately 22, and we will build our memo in class. Look forward to doing that with you all.